Hello, everyone, and welcome to this Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to be hosting this Courthouse Steps Decision webinar on the recently decided Diamond Alternative Energy versus Environmental Protection Agency. We're very pleased to welcome our excellent speaker, Ellie Nachmani, to this discussion today. Ellie is an associate at Covington and Burling. And special thanks to Jeff Bielert for moderating this event. Jeff is a partner at Givens Pursley. If you'd like to learn more about today's moderator or speaker, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. So if you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. And finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. And with that, Jeff, thanks for joining us today. I'll hand things over to you.
Thank you, Edie, very much. And thank you, Ellie, for joining us, taking the time to talk about Diamond Alternate Energy versus EPA. Our goal today is to spend about a half an hour, maybe 45 minutes talking about the case between the two of us, and then to open it up for questions. So if any one of the participants, if you have questions, we'd like to reserve about 15 minutes for us to address any questions that may arise. But I just want to talk a little bit about the case. This was one of, I think it was like 5 decisions that were handed down on Friday. And it's a 7-2 decision. And in a 7-2 decision, Justice Kagan joined the majority. And she joined the majority in this case, as well as 2 other cases that were decided the same day. And so I'd like to talk a little bit about what's going on in this case and also sort of what's going on with the dissenters. But first, Ellie, I don't know if you want to take a shot at just what's going on in this case. What is this about? It's an EPA case. It's an environmental case. If you just want to talk a little bit about the background and sort of the legal issues that the court was deciding.
Yeah, absolutely. So thanks so much, Jeff, and thanks also to the Federalist Society for having us here today. I should note that any expressions of my opinion are my own and not necessarily representative of those in my firm. Diamond Alternative Energy, LLC against EPA, it's an EPA case, it's an environmental law case, it is an administrative law case, but perhaps most importantly for the court, it is an Article 3 standing case. So the case is based on a lawsuit brought by both states and fuel producers, and the important part here is the fuel producers, against the EPA's decision to grant a waiver to the state of California, allowing it to evade what ordinarily would be federal preemption on development of their own fuel standards for cars. So the EPA, and the EPA has ping-ponged. So the George W. Bush administration, didn't want California to have its own standards. The Obama administration allows via this waiver California. The Trump administration revokes it. The Biden administration reinstates the waiver. This suit concerns the Biden administration, EPA's agency action to reinstate the waiver. So the waiver allows California to develop fuel standards that regulate automobile manufacturers, and the fuel standards tell automobile manufacturers, here's how you need to develop your cars in terms of their fuel economy and the like. And you can imagine that if cars are developed in a certain way, maybe to require less fuel, fuel producers who are not regulated by the California standards that are only in effect by virtue of the EPA having granted them this waiver, they're not directly regulated by the California standards. It's the car makers who are regulated by it. But they say what's going to happen here, you can understand the likely effect is that as car manufacturers make less cars that are gas powered or make cars that require less gas, that's going to lessen the demand for our fuel. And so we believe that we've suffered an injury, and that injury is caused by the EPA granting this waiver. And that injury that's caused by the EPA is redressable by a court invalidating the EPA's waiver, thereby preventing California from allowing these fuel emission standards to go into effect. That will, of course, allow the car manufacturers to manufacture the cars they were going to do anyway, and thus there will be the same amount of demand for our fuel, or at least more demand than there otherwise would have been in the absence of the California standards. So the
Yeah.
DC Circuit, oh, sorry, Jeff, go
No,
ahead.
I was going to say, I don't mean to jump in, but let's the frame of when this waiver would have been in effect, because I think that the justices, there's a bit of, by the dissent, I think Justice Sotomayor, right? She sees this as a super factual issue. Look, the Trump administration is going to get rid of this waiver anyway. There's only a short period of time in which it would have been in effect. I'm just curious, what's your view of sort of the factual situation of when this waiver actually would have been used, or how the court was looking at sort of that factual issue?
Yeah, so the court acknowledges that the DC Circuit's opinion may have rested in part on a factual misunderstanding of what was going on here. So the DC Circuit thought that neither of the California regulations, so there were ones through model year 2025, and there's another one that the court addresses in a footnote and says the Congressional Review Act is basically dealing with those with the new Trump administration now in office. But the problem was the redressability as to the motor vehicle manufacturers' fleets by model year 2025. And we're already in 2025. And so, there's this underlying question of, what's going to happen to the cars maybe as of the period of time within which the waiver was allowed to operate. But what the court says is also you have to think about how manufacturers are going to change their fleets as well, maybe going forward, and what the ultimate goal of the regulation was by California was not just within the small framework of, okay, well, what happens within just model year 2025. California was seeking to affect a market for fuel standards. Now, the DC Circuit, when it's evaluating redressability, sort of looks at this and says, well, we don't believe that the fuel producers have put sufficient evidence into the record to indicate that the car manufacturers wouldn't otherwise be going down this path. This is this idea where maybe there is enough supply, for example, of electricity, or there's enough consumer demand for electric cars, that the automakers were going to go down this route anyway. The court responds to this and says, yes, but the EPA is still defending the waiver and California is still defending its regulations. And so even if it's the case that there will be $1 less of demand for fuel, regardless of maybe there was a slight factual misunderstanding in the DC Circuit, there were other elements of the DC Circuit's understanding of what exactly was going on here that allow us to conclude that and this is actually a substantial part of the opinion, that the fuel producers are an object of the regulation, despite being what we might call in other administrative law cases an unregulated third-party plaintiff. And so the only way that the fuel producers can achieve some sort of remedy is for the invalidation of the EPA's waiver. It's a fascinating footnote in the court's opinion, footnote 3, where, and this is an opinion by Justice Kavanaugh, who has been a leading proponent of this view. You can read his concurrence in Corner Post. Justice Kavanaugh says, we use the term setting aside as shorthand for invalidating the EPA's waiver, because really that's the only way that the parties here, the fuel producers, are going to be able to get complete relief, is if you invalidate a waiver allowing regulation of a party that's not before the court, that has not brought this lawsuit. This seems somewhat to be in tension with a position that Justices Thomas, Gorsuch, and Barrett have articulated in the past. Justice Gorsuch's concurrence in United States v. Texas is an example of this, where Justice Gorsuch says set aside really means set aside as to the plaintiff before the court. So this question of vacatur under Section 706 of the Administrative Procedure Act. So it's a fascinating footnote, joined in full without comment by the justices who have expressed skepticism about Section 706 set aside meaning invalidate. Now, to be fair, it's a Clean Air Act case, so maybe a little bit different. But it's an interesting commentary, I think, on remedies, and is set up by, maybe there was a factual misunderstanding in part, but the DC Circuit did rest its finding on redressability on this more broad understanding of what's going on here.
Yeah, and so I think by the time it gets to the Supreme Court, and I want to unpack a little bit of this that we were just talking about, but the Supreme Court and Justice Kavanaugh in the majority opinion sort of goes out of his way to say, this case only concerns standing, and that you have injury in fact, you have causation, you have redressability, and really the EPA in California aren't even challenging sort of the first two issues, right? That like we're not even in a world in which they meaningfully dispute injury in fact or causation. What they really are dealing with here is redressability. And I think the court, and maybe agree, that the majority opinion is trying to sort of tease out those arguments. But one of the things that the court suggests below, and I want to talk about this just as a litigator, right? That the EPA itself did not challenge Article 3 standing in the DC Circuit. And Justice Kavanaugh sort of chastises the agency and it says that, EPA's silence on standing was telling, right? He describes it as the proverbial dog that didn't bark, because the EPA routinely challenges a party's standing, and the agency believes that there is no injury in fact, causation, or redressability. And here he says that the EPA's failure to do so suggests that the EPA itself believed that the fuel producers had standing. And I'm just curious, like, what do you make of that? I mean, it seems to me like the government, for a whole bunch of different reasons, may decide not to raise this or that argument. But here, it seems like the majority, or at least Justice Kavanaugh, joined by his colleagues, are faulting the government for not raising standing arguments and somewhat discrediting the fact that it had to be an intervener, the state of California and other parties, that actually brought up the sort of standing argument. What do you think?
Yeah, from a practitioner's perspective, I thought that was remarkable. Now, to be fair, parsing the majority's opinion, all it says that is that the EPA's failure to raise standing tends to suggest that the EPA believed that there was standing here. Standing is one of these, might call it a weird doctrine in which the court can raise it sua sponte. And so it's not necessarily the case, even if both parties agree that there is standing, and maybe, against the interests of the defendant believes they're standing, the court itself can raise it and make a conclusion that there's no Article 3 standing, because Article 3 standing goes to the power of the federal court to exercise the judicial power of the United States. I don't know how that cashes out in future cases, because the majority's opinion, read plainly, merely has that as a line there to tell you about what the EPA thinks. But whether what the EPA thinks about Article 3 standing has any legal significance was not clear to me. The court still goes through an entire rationale of Article 3 standing that is defensible on its own grounds. It doesn't rely on the fact that we're unsure about Article 3 standing here, and so the EPA's failure to raise it tips us in the direction of thinking that there is. And this kind of thing happens regularly, where you have an intervener who wants to make a different argument, and that's what the state of California does here. It's a position that got at least two justices on the court, at least two justices to say we should remand this back to the DC Circuit to maybe do a little bit more factual finding. But I thought it was significant, and you wonder if this is only the sort of thing, to the extent that there is some legal significance here, that has to do with the government as an institutional repeat litigator that often challenges standing in agency cases. Or is this the kind of thing where, in a case between two private parties, we might say the failure to raise standing on the part of the defendant suggests that maybe, in fact, there is standing here, notwithstanding the court's independent obligation to determine whether Article 3 standing exists for the case to fall within the cases and controversies under Article 3.
Yeah, so I mean, it seems like you can't waive standing, right? I mean, even in the example that you're given, and there's two other private parties, using Justice Jack, ordinary citizens, right? Not these well-heeled lawyers in marble facade buildings, right? I mean, the idea that like in another case, you may have one party, a defendant, not raising a standing argument, but I don't see how that changes anything from a constitutional perspective, that the court has to make sure that it actually can decide the merits of whatever the dispute is. So maybe this is just, I agree with you, sort of the idea that the government is a repeat player. The government frequently does this. I don't know that there's much to be read into this other than to suggest that courts still need to analyze standing, and the court does so, right? And I think that Justice Sotomayor in her dissent suggests, look, we didn't even have to do this, right? Just last term we had a standing case. Why did we take this case? What are we doing here? And I think that, obviously she didn't get the votes, right? She's writing for herself. Justice Jackson's writing for herself. 7 justices disagree. They obviously have a majority opinion here. But I'm curious, do you think that the dissenters pushed away Justice Kagan? Because Justice Kagan joined the majority in this case. She joined the majority in 2 other cases that were released the same day in 7-2s. What do you make of Justice Kagan joining Justice Kavanaugh's majority decision?
Yeah, it's tough to say. I thought it was a notable signal that Justice Kagan, who was an administrative law professor and well before taking the bench, joined the 6 justices who typically are thought of as conservative coded, especially on administrative law issues. You have a shorter dissent by Justice Sotomayor keying in on the factual misunderstanding, and there seems to be a difference between the majority and Justice Sotomayor on the exact nature of that factual misunderstanding and how, in particular, it cashed out with the DC Circuit's standing analysis, whether this case may have been appropriately before the court. And then you have Justice Jackson's dissent, which takes a different tack. Justice Jackson's dissent seems to suggest that the majority applies the standing doctrine here to allow the plaintiffs to bring their lawsuit forward. And maybe there's this, dispute about the meaning of set aside under either the APA or the Clean Air Act. A rebuttal to that might be, well, you sort of just assume that the remedy that the plaintiffs seek is available for the purposes of Article 3 standing, and then we can fight later on about whether that remedy actually is available. We're just determining whether, if the remedy was available, it would be redressable. But Justice Jackson says that the majority applies the principle here, but that the Supreme Court has not really taken a broader view of standing, in particular on redressability, to allow plaintiffs to sue in other cases. She cites some cases. Justice Kavanaugh responds with some cases. There was commentary on the Volokh conspiracy blog. Professor Josh Blackman put out a post saying that the examples in the majority opinion largely reflect sort of ideological strategic litigation that may not be exactly on point in response to what Justice Jackson is saying, which seems to suggest that in that dissent, maybe big business has an easier time getting standing before the Supreme Court. Here, of course, it's a lawsuit by fuel producers against the EPA about fuel emission standards. But Justice Kagan doesn't join either of those opinions and joins the majority, which applies, in my estimation, a pretty straightforward analysis of the Article 3 standing question. Justice Kagan appears also to believe that the injury here is not only redressable, but also maybe would be redressable by invalidation through the set-aside language based on some of her past jurisprudence. And so I thought it was the sort of thing you might describe as a strategic join. But I have no reason to believe that she not only fully bought what the majority was saying, but maybe just didn't agree with some of the criticism, both on the facts and perhaps on the broader applicability of the ruling by the dissents.
Yeah, and I think, at least for the majority, right, there's an element of sort of common sense, right? And I think Justice Kavanaugh in the majority's decision is suggesting that, why would EPA in California enforce and defend these regulations if their argument actually was correct, that invalidating them wouldn't change anything in the market? And maybe this is, a litigating position. I mean, they're responding to the petitioners in some sense, and they're fighting off this idea that invalidation may not actually have the intended consequences, or at least that the petitioners are suggesting that it would, right? That the idea that getting rid of California's waiver necessarily means that, to put it in your terms, or the terms that Justice Kavanaugh used, it, there's a dollar that may actually matter, that there's monetary consequences that flow from this waiver, and that the fuel producers, if they're successful in getting this waiver invalidated, that there's going to be some impact in the actual market. And I think Justice Kavanaugh, in his sort of response to this, is, that, well, if EPA and California actually believed what they're saying as a litigating position, then just as a matter of common sense, what's the purpose of this waiver? And, Justice Kavanaugh, I think he suggests the government generally may not target a business or industry through stringent and allegedly unlawful regulation, and then evade the resulting lawsuit by claiming that the target of its regulation should be locked out of court as an unaffected bystander. And I think, Justice Kavanaugh and the majority, right, are taking this sort of common sense view that, the purpose of this waiver, the purpose of California standards, is specifically to encourage electric vehicles and to decrease the amount of gas-powered or fuel-powered vehicles. So, what do you make of that? I mean, it seems to me like the dissenters sort of disagree, right? That, like, to your point, that maybe less powerful plaintiffs, in the terms of Justice Jackson, that they're not getting this sort of common sense benefit of the doubt. You think she's right on that?
It's not obvious that she is. I mean, she has a few cases that she cites. One of them being this case from 1984, in which the court obviously was very differently composed. But as she describes it, it was the holding was that a group of Black parents lacked standing to challenge the Internal Revenue Service's policies concerning tax exemptions for private schools. The parents there had alleged that the IRS's failure to deny tax-exempt status to racially exclusionary private schools in their communities was hindering desegregation efforts in the districts their children attended. There's this question of where the common sense economic principle will lead. The idea that there's a regulation on the books, that, or really what we should say here is there's an agency action on the books that allows a regulation by a state to be on the books, to regulate fuel producers, or to regulate, I should say, car manufacturers in a way that might have an effect on fuel producers, likely will have an effect on fuel producers. You can envision a way in which the EPA wants to grant this waiver without really believing that there's going to be some impact. And again, it's the EPA who's at issue here. It's their agency action that's challenged. And so you might say what the EPA is attempting to do here is have a respect for federalism, allow states to, do their own policies as opposed, to having one federal standard. Now, there's the follow-on question, of course, of whether that was within the ambit of the Clean Air Act and whether they were allowed to. But just, stepping back for a moment, maybe there's some federalism interest here. But the way that Justice Kavanaugh's opinion describes it is, you mentioned earlier that the fuel producers were a target of the regulation. The examples that the majority opinion uses, you can tell that Justice Kavanaugh was thinking about baseball season. One is that if there's a regulation banning the sale of hot dogs at a stadium, that the object of the regulation is not just the stadium who's prohibited from selling the hot dogs, but the hot dog manufacturers, because there's going to be less sales of hot dogs. Similarly, if the government bans aluminum bats in Little League, it's not just the Little League that is the object of the regulation, but it's the producers of the aluminum bats. So I think the way this cashes out is we have a new understanding, or maybe an application of a long-standing understanding, but at least made explicit in this opinion, of who the target, who the object is of a regulation, and how does that work in the context of standing when, again, what you have here is an unregulated third-party plaintiff, but one that is saying, well, there's a predictable economic consequence here. But Justice Jackson does have a few examples where she says, well, look, apply the principle, and there are cases in which we have held that there wouldn't be redressability. That the court, for example, in Allen v. Wright in 1984, says that that injury was not redressable by favorable judicial decision because it wasn't obvious that the desegregation efforts would succeed. There's another one, Clapper against Amnesty International in 2013, a case sort of involving surveillance and possible terrorism. So, Justice Jackson does bring some examples to bear, but I do think that the majority's opinion here is persuasive on the point that if you're an object of a regulation, and maybe we agree that the fuel producers are an object of California's regulation, you're going to be impacted by that regulation, and that injury would be redressable by the vacatur of the waiver.
Yeah, and I mean, this again may be a little, common sense, right? I mean, California is concerned about emission standards. It's concerned about what it views as clean air. It's concerned with greenhouse gas emissions. The whole purpose of this waiver was to allow California to set stricter standards with the goal of reducing, the amount of automobiles that are on the roads that are relying on fuel, that are relying on gas-powered engines. And so, from my perspective, it does seem to me like the state itself and sort of the language that the state itself, that California used, in some ways was used against it, right? That like this idea that, well, even if you were to set aside this waiver, it wouldn't really matter because no matter what, the demand is there for electric vehicles or whatever the arguments that California is making. But Justice Kavanaugh, I think, rightly points out, then what's the purpose of this regulation, right? The whole idea that you're getting this waiver to set these stricter standards is so that you can do what it is that you're saying that you seek to do. And so I do think that maybe this is unique in the context of a Clean Air Act case. And maybe it's not as broad as maybe Justice Jackson is suggesting. But I wonder, I mean, she uses pretty strong language. I mean, I think that she's attacking this idea, and I don't know if it's chastising her conservative colleagues, but the idea that like the Supreme Court is highly selective in the cases that it takes, and that it's being overly sympathetic to corporate interests in this case, right? And that it's not applying the sort of same standards that it does to ordinary citizens. And, I think, in my own view, the reason why Justice Jackson's writing for herself, and the Justice, Kagan didn't join this is the law is the law. And in some ways, the things that she's talking about, this idea that sort of well-heeled lawyers and lobbyists are somehow getting more from the court than what an ordinary citizen would, I'm not sure that idea is shared by any other justice than Justice Jackson. I mean, it seems to me like she's taking shots at her colleagues in a way that I'm not sure matters in terms of the legal issues that the court was deciding.
Yeah, look, the Supreme Court takes each case as it comes, and it has to. As to the facts of this particular case, is it likely or unlikely that the fuel producers are going to have their asserted injury redressed by invalidating the EPA's waiver to California? We can strive for, and in fact, maybe really prioritize doctrinal consistency, working with, the different precedents that the court has handed down over the last 40, 50, 200 years about what is the ambit of the Article 3 courts and which disputes count as cases and controversies. But I think the criticism of, the majority has a rule and it's not applying the rule fairly is maybe a step removed from the question of whether the rule is right. And it does seem that, Justice Jackson may be alone on thinking that the opinion is one that doesn't fairly apply the standing precedents. But again, I think taking it on its own terms, the court is just correct here that this injury is indeed redressable. setting aside, pun intended, setting aside what your views are on whether the remedy actually is available that the fuel producers assert that they're entitled to of invalidation.
Yeah, I tend to agree. We mentioned this earlier, and I think you sort of the idea that agencies are going to flip-flop. The majority talks a little bit about this. I think, after Loper Bright, like, what is this really going to mean? Chevron, Brand X, the precedents that existed before Loper Bright, agencies were allowed to do this. They were allowed to do this even after a court may have taken a different view of the statute. It seems to me like Justice Kavanaugh, in the majority decision, rightfully points out different administrations have taken different views as to California's waiver. And you sort of have this period of time, I think you mentioned, right? The Bush administration doesn't want a waiver, Obama's administration does, Trump administration takes it away, Biden administration puts it back, right? What do you make of sort of the flip-flop nature of agencies and what that might mean, just as a general sense, going forward in sort of these, whether you consider this an admin law case or, a pure standing case? It's something that the majority talks about. I don't think that it's relevant necessarily to the standing argument, but like Justice Kavanaugh does discuss this. And at least for the dissenters, I think the idea that, well, none of this really matters because, as you pointed out, it's only the 2025 standards, and the Trump administration is just going to get rid of the waiver anyway. Maybe this case is just moot.
That may be right as to this particular case, and it should be noted Justice Jackson in dissent observes that in his first term, President Trump rescinded this waiver. EPA acknowledged that it was actively considering whether to grant this waiver or to rescind this waiver. A withdrawal of the waiver likely would moot this case. But I found it amazing as you recount the timeline, going back and forth from the Bush administration to the Obama administration to Trump 1 to the Biden administration, and now we'll see what happens in Trump 2. How there really is an elections have consequences element to what the agencies are doing here. And it's one that really is likely going to be unaffected by the court's decision in Loper Bright. So if you're an administrative law enthusiast, you may have thought Loper Bright put an end to regulatory flip-flopping, or what Aaron Nielsen once described as regulatory zigzagging. The issue of one agency adopting one legal interpretation, another agency adopting a policy-laden different legal interpretation, and courts allowing the agencies to change their positions there. This, by contrast, is not a different legal interpretation, but it's a policy decision. And that policy decision is going to be determined under the arbitrary and capriciousness standard, as many policy decisions are. And I think you can combine this case with another case about which we did one of these webinars. This is the FDA v. Wages and White Lion case, which was about the agency change in position doctrine, how deferential to be. And the court really seemed to close ranks on this idea that agencies are able to change their policy decisions as long as they articulate a justification for it. And so I think going forward, regardless of what happens with this particular waiver, this case is an example of the fact that I think agency flip-flopping, at least on policy decisions, is probably here to stay, notwithstanding the decision as to legal interpretations in Loper Bright. And those policy decisions are going to have litigation as a background component. When one administration changes the policy, you're likely going to get an arbitrariness lawsuit by a group maybe, or a litigant who might have some association with the ideological priors of the party that's not in power that had the original decision, or would, if elected in the next election, change the decision. But for those who were super excited that regulatory flip-flopping was gone after Loper Bright, may I introduce you to agency policy decisions?
Yeah, I tend to agree. This was not, contrary to Loper Bright, right? We're not dealing with statutory interpretation here. We're dealing with, as you pointed out, policy decisions that administrations are free to make. So, but it is something that, Justice Kavanaugh discussed. I think that there certainly are examples of one administration taking a policy position and another administration undoing that. And I agree with you. I don't see how that's necessarily going to go away. I want to ask, I'll get to maybe some of the Q&A here. We've got a couple of questions that we've received. For those of you that are listening in, I encourage you to ask questions that you may have, but I'm going to ask the first question that we received, and this is, will this decision result in the potentially unintended consequence that third parties, such as NGOs, have an easier burden to demonstrate that they have standing to challenge administrative agency actions? What do you make of that?
Well, I think the first thing there is Justice Jackson would likely say, what do you mean unintended consequences, right? Like if her dissent is to be taken seriously and maybe thought about in future cases, this is just a decision that makes it easier for a plaintiff to get into federal courts. The likely cash out of that is because the decision, I think, has far-reaching consequences for who the object of regulation is, who is the target of regulation. It's probably the case that it makes it easier to sue the government. And depending on the administration in power or the things that an administration wants to do, to the extent that a litigant can allege that there's going to be some sort of follow-on economic consequence that we, applying common sense economic principles, can see obviously follows from the regulation, yes, this decision likely does make it easier for a plaintiff to get into federal court. I don't know that the majority would describe that necessarily as an unintended consequence. Perhaps folks who are part of, the conservative legal movement who, see standing as being a way in which to advance limited government, to have less regulation, they might describe that on the basis of their ideological priors as an unintended consequence. And there's academic literature about this. I think Richard Ray has a thing out recently. I don't know if it's an essay or an article where he basically catalogs this sort of ideological realignment on Article 3 standing, where conservatives have become in recent years more favorable to the idea of plaintiffs bringing lawsuits in federal court, and a good portion of those lawsuits that conservatives are excited about, not only, of course, civil rights lawsuits or lawsuits brought by strategic ideological litigants seeking to advance socially conservative causes, but also these sort of limited government regulation is bad type lawsuits. But I think Justice Jackson would say, well, you just sort of apply the rule fairly, and if that means that litigants who might be more left-coded get into federal court, that's the rule.
Yeah, and so Justice Kavanaugh also, in the majority decision, there's a discussion of sort of the declarations that were submitted, and I think he takes a view of this, that you are allowed as a litigant, just as a practical matter, right? So if you're looking at this decision going forward, and you might be an NGO or a advocacy organization, or there's something that you want to challenge in terms of administrative agency actions, you don't need to have some sort of expert market analysis of the consequences of the regulation, right? And I think this, again, it may be like a litigating position that the EPA and the states took in this case, but they tried to attack the declarations that were submitted by the fuel producers, suggesting that this waiver actually does have a direct impact on, say, their sales and the sorts of things that they put into those declarations. And I do think that if you want to take something away from this, the majority makes it clear that you don't need anything other than sort of your normal sort of run-of-the-mill declaration. You don't need to hire economic experts to really show in some stringent way that this is exactly the damages that are going to result. That you're allowed to come into court, you're allowed to make sort of your case in a way that's like, yes, it's going to impact us in this way, and it doesn't need to be experts that do that.
You don't need to hire economic consultants in some instances. The court also has a paragraph that I think is going to become pretty important on its page 19 of the slip opinion, where they express skepticism about requiring plaintiffs to produce affidavits from regulated parties when the plaintiffs themselves are these unregulated third parties who are relying on common sense economic inferences that you might make from what is going to happen from regulation. And the majority opinion, which I think takes exactly the right view of how a lot of these sort of agency proceedings might go, or how agency relations with regulated parties might go, is that some regulated parties may not be willing publicly to oppose the government in this litigation, or possibly antagonize the government regulator through an affidavit that would be supportive of a lawsuit challenging what that government regulator wants to do. And so I think that the court takes a practical realities approach here to how a regulated party might interact with the unregulated third party plaintiff who wants to sue based on how the regulated party's conduct in light of the regulation is going to affect the unregulated plaintiff's market share in a given market. So I think that's one where we're going to see citation to that paragraph about the burden on an unregulated third party plaintiff to produce certain affidavits. And you might say, well, the court should make the inference here that there's going to be harm, because to do otherwise is going to require us to get an affidavit from somebody who you might understand as reluctant to get such an affidavit.
All right. I want to turn to sort of the second question, and we've got three. If any others have questions, please submit them. But this question asks, did this case actually turn on the procedural failure of the fuel manufacturers to timely submit evidence of redressability?
I think this goes back to the point that we just discussed. This is this idea of, what affidavits exactly do you need to submit? What evidence exactly do you need to submit? And I think the court takes a stand here for economic inferences that you can make. There's this idea that California, with the blessing of the EPA, and without the blessing of the EPA would not be able to, but California, with the blessing of the EPA, has put up a legal barrier to the sort of conduct that the car manufacturers, we can assume, were engaging in prior to the issuance of the regulation. And so without that legal barrier on the books, I think the court says you can infer that that legal barrier having been taken out will necessarily not cause as much of an injury to the fuel producers as they would suffer if this legal barrier intended to cause the injury that the fuel producers assert that it is or will cause is in place. And so I think, part of this turns on what exactly was the evidence that was submitted. The DC Circuit, in its opinion, the case, is titled Ohio v. EPA in the lower court, because you also have the state petitioners here. But the DC Circuit is interested in the evidence that is submitted, but I think the majority is resting on this idea of common sense economic principles with an idea toward what exactly you need to submit, and maybe more importantly, what is feasible to get in terms of affidavits and declarations when trying to support Article 3 standing in a case like this.
Yeah, and I mean, we talked about this. For Justice Sotomayor, this is sort of a factual dispute. This, the DC Circuit didn't consider the proper factual issues, and this should just have been remanded. The court did not need to go where it went. Again, coming back to this idea of like common sense, California was very clear on what it sought to accomplish. And the reason that California has this waiver is specifically so that it can impose stricter standards that are meant to discourage consumers from purchasing, fuel-driven cars, that they're going to be relying on electric vehicles or, as you pointed out, cars with better fuel economy. But I do think that there is sort of this common sense element that for the majority, right, you can use the language of California itself and use it against it to suggest that, look, there has to be at least some amount of damages that they're going to impose on the fuel producers. I want to ask this third question. Justice Jackson pointed out that it is hard to reconcile Diamond Alternative versus EPA, this case, with Murphy versus Missouri, a 2024 case. And then there's a quote from the Murphy majority that it is a bedrock principle that a federal court cannot redress injury that results from the independent action of some third party that's not before the court. And the question asks, well, the majority in Diamond Alternative, it doesn't address Murphy. Do you think that those two cases can be reconciled?
I think they probably can. The third party analysis in Murphy, as I remember it, wasn't necessarily based on direct government regulation telling a party you have to do this on pain of an enforcement action pursuant to a regulation that we have duly passed through our state's legislative or administrative process. And so here we might think that the third party who really we're after, so this case comes down to it's a chain of events that we've determined is not speculative. So the chain of events is EPA grants the waiver, California imposes the regulation, the car manufacturers, in complying with that regulation, are not going to produce as many gas-powered cars or cars that require as much gas or other sorts of fuel producers sell by virtue of needing to follow those regulations. And thus, at the end of that chain of events, the fuel producers are harmed. The link here that we're really concerned with is not so much the third party California, it's the third party, the fuel producers. And so, based on the what the fuel producers are doing, I think we can say that it's likely, it's predictable that the fuel producers are going to have some sort of reaction to this regulation, are going to do something different than they were doing previously. And so here, I think we can determine that that's a predictable, or the word that the court really uses is likely, impact that a regulation is going to have on a third party, and thus cause the injury that will allow us to think, okay, there's a redressability here if we can stop that chain of events from going into effect in the first instance. Because I think really the syllogism here is no waiver, no California regulation, no change in the manufacturing of the cars. And as I understand it, Murphy did not have nearly as clean of a cause of events there, based on what the court is really focused on here, which is direct coercive government regulatory action that you either comply with, or there's going to be an enforcement action grounded in an existing law that tells you not to do the specific thing that the petitioners here wanted them to be able to do.
Yeah, and I think you're right that the majority decision uses that term, likely, right? So if you are someone like the fuel producers, you're a litigator, and you're not necessarily what you described as like the regulated party, but you're unhappy with an agency action, then that's the sort of, I guess, causation chain, the causal chain that you're going to have to establish and to explain to the court that your injury is likely, and that by invalidating the agency action or whatever it is that is being challenged, that you're likely going to be able to redress that injury. And so I think that in that sense, this is the court, or at least for the majority, it's the court explaining that once again. And I do understand that there may be an argument to be made that, look, we didn't need to take this case, we didn't need to address all this stuff, but I do think there are some issues that the court did provide clarity in this case in a way that it hasn't before. And so the sort of takeaways, and I want to end with this, is sort of, what do you view as really the takeaways from this decision, the things that we should be paying attention to going forward?
Yeah, so I think there's a few takeaways, and I think there's a few or maybe really one big dispute that's teed up here. So I think the number one takeaway is you can understand an unregulated third-party plaintiff as the object of regulation, as the target of regulation, even if that plaintiff's cause of action depends on what we think a regulated third party who's not before the court is going to do. Here we have a group that is not the direct target of the regulation, but nevertheless is considered to be a target or an object of the regulation for purposes of Article 3 standing. Another is the reaffirmation of this principle from the case Uzwig-Bunam from, I believe, 2021, and that was it was a civil rights case. I believe it was a free speech case, which affirmed that $1 of nominal damages is enough to constitute an Article 3 injury. We've now brought that into regulatory litigation, where $1 of economic injury involving maybe less fuel sales is going to be enough to establish redressability. The court, I think, straightforwardly understands that there's an injury here and straightforwardly understands causation by the EPA, notwithstanding the fact that California's regulatory scheme is really the thing that's at issue here, and we're worried about the waiver. So I think, there are some takeaways for the doctrine of Article 3 standing. Another takeaway that we've talked about is this idea of regulatory flip-flops being here to stay. Litigation is going to be in the backdrop of these flip-flops. FDA v. Wages and White Lion may be the more relevant citation here for what the court is going to do with those regulatory flip-flops, but at least here, it's now maybe a little bit easier to sue the government and establish redressability. And so this case probably either widens or clarifies the existence of a larger subset of potential plaintiffs for these kinds of cases than maybe we would have thought prior to this case coming down. And then I think the main dispute that's teed up here that's going to be interesting to watch going forward is, to the extent that the redressability analysis relies on the need for invalidation of the agency action, is invalidation actually available? You can envision when there's a case involving a plaintiff who is directly regulated by an agency action, and that plaintiff seeks to say that the term set aside in Section 706 of the APA, and again, I know this is a Clean Air Act case, but just the terminology, Section 706 of the APA. When they say we want the agency action to be set aside, if they say we want the court to invalidate a national regulatory program because we don't want to comply with it, there are some justices who appear to believe that, yes, that's the proper remedy. That's what set aside means. There's other justices who have taken a different approach, who have said set aside only means that you individually are not going to have to comply with this agency regulatory program. This opinion presupposes that the first answer there is right, that set aside, at least to some plaintiffs, right, because this is not a directly regulated plaintiff, this is an unregulated third party, set aside may mean invalidate. The set aside remedy under either formulation is going to be available to that plaintiff who is regulated. But set aside doesn't really appear to mean much to this plaintiff, and maybe the remedy would not be complete as to this plaintiff if all it means is the regulation is not enforced against you. Justice Kavanaugh concurred in another case called Corner Post from last term, where, and I'll note this briefly, Corner Post was a truck stop merchant that said, we think that the Federal Reserve set the merchant fees that are allowed to be charged by the credit card companies at a rate that's improper. Corner Post is a regulatory beneficiary of those caps on the rates that the credit cards can offer. And Corner Post litigated the case. They sought vacatur. And Justice Kavanaugh said, as concurring as an aside, by the way, the only reason this case can can work is that a vacatur is available as the set aside remedy. Here, however, you don't have necessarily a regulatory beneficiary, but it's somebody who's also aggrieved by the natural follow-on effects from regulation. So I think this case presents an interesting new scenario that jurists are going to have to grapple with about, okay, if set aside means a more narrow relief, what happens to these sorts of cases? And so I think there's a lot here. It's a really interesting case and could wind up being one of the underrated ones from this Supreme Court term.
All right. Well, I appreciate your time. Thank you to all who have joined us. This will be available online if if anyone wants to watch it again. And thank you very much to the Federalist Society. Thank you, Ellie, for participating, and look forward to participating in future events.
Yeah, just to echo that, on behalf of the Federalist Society, thank you so much to Ellie for speaking with us today about this decision and Jeff for moderating. We're so grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate you participating. You can stay up to date with announcements and other upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.